This podcast is brought to you by PLI, the Practicing Law Institute. PLI is committed to keeping you ever current on the dynamic trends shaping the legal world. Learn more at pli.edu/ftpod.
Welcome to Fast Tracked, Emergent Issues in the Legal Profession, brought to you by the Practicing Law Institute. I'm your host, Jen Leonard, founder of Creative Lawyers. Buckle up as we hit the gas and explore the most dynamic trends shaping the legal world, from generative AI to DE&I and everything in between. I hope you'll join us as we explore the future of law today. On today's episode, we talk with Alice Armitage, Chief Executive Professor of Lex Lab at the University of California Law, San Francisco, and Heidi Brown, Associate Dean for Upper Level Writing at New York Law School and author of The Flourishing Lawyer. We're going to talk with Alice and Heidi about the future of law firm associate development in a rapidly changing world. Let's dive in. Welcome, everybody. We are so thrilled to have you back on PLI's newest podcast, Fast Tracked, Emergent Issues in the Legal Profession, where we talk about all of the converging forces around us right now that are driving an unprecedented era of change in the industry. And I am so delighted today to be joined by two of my favorite thought leaders, educators, and forward thinkers with respect to lawyer formation, legal education, and lawyer and law student professional development. We are joined today by Alice Armitage, and joining Alice today is Heidi Brown. We are so delighted to have both of you today to think about what the future means for the lawyers entering the field today and tomorrow. And I'd just love to start, Alice, I'm going to start with you. How would you describe the current state of lawyer formation programs in the U.S. today?
Well, it's interesting that you asked that question because, first of all, I don't think that lawyer formation has ever been much of a focus for either legal education or for young associates going into law firms. And yet the technology, all the changes happening today are really creating a kind of change that the law firms aren't prepared yet to teach, and neither are the law schools. And so the students are coming out without understanding how important it is for them to have not just the ability to think like a lawyer, that's sort of table stakes, but the interpersonal skills, the leadership skills, the understanding tech in a way that they've never had to before. And so I think that really something has to change, because I think right now we're not doing young lawyers any favors. And I believe law firms and legal departments are going to want to change that, because they're going to see how inefficient it has been to let people just learn on their own by osmosis, as we've all had to do in the past.
Yeah, and I know, Alice, we've talked before. You visited my class on several occasions. I don't know if you have the ability to sort of share briefly why it is that lawyer formation is so disconnected from practice, because as I understand it, it has very deep roots in the design of legal academia itself.
Well, legal academia is really just all about the theory of the law, the history of the law, really, and jurisprudence. And that was always thought to be enough. Legal education was about, again, thinking like a lawyer and having some doctrinal knowledge, substantive knowledge, so that when you went out and practiced law, someone came in with a question, you'd sort of heard of it before. You had a little knowledge about everything. But these days, now that a chatbot has passed the bar, it sort of seems a little silly that we focus on knowing a little bit about everything. We can find subject matter very easily online. And what we need to be able to do is have that kind of nimble thinking that allows us to have very unusual fact situations. We're no longer, we look at precedent as we always have, but often the facts don't even fit, when it's something that's coming out of artificial intelligence or something like that. And so lawyers now they can't just go into their memory banks and say, oh, what did I learn about that in law school? It's like, oh, this doesn't really fit, but how am I going to tweak it or how am I going to even think about something that's so cutting edge that there is no precedent? And for that, I think that the skills of being able to think nimbly and with agility and to maybe not get it right the first time, but try again, that iteration skills are all things that are more and more important than they used to be in the law. And again, we don't teach them. And I don't think I ever learned that in law school or frankly, in the first few years of practicing law. That was just not, the way it was done. You were just buried in documents or contracts or whatever it is, whatever area you were in, and tried to learn by being exposed to them. And I don't think that's really, that's not bringing out the best in the young lawyers that we could today.
Thank you so much for those thoughts. And Heidi, I know both you and Alice and we all had practice backgrounds at the beginning of our careers and then have spent so much of our time over the last few decades really thinking critically about the profession and the formation of junior lawyers' minds. What are your impressions right now of the state of lawyer formation based on all of that contemplation and action that you've taken?
Well, I agree with a lot of everything that Alice said. And when I think about lawyer formation programming right now in legal education and also in legal practice, I personally feel like I have a little bit of whiplash. And I feel like students and junior lawyers probably feel the same thing because there are, positively speaking, a ton of different initiatives across law schools across the country, a ton of different initiatives at specific law firms and in bar associations. But to me, there's not really a common thread or through line. People are just kind of reacting to new ABA standards about professional identity formation and doing good things. But to me, the word whiplash just keeps coming to mind because you think about, law schools across the country are engaging in a variety of different models. Some have completely dedicated departments and directors toward lawyer formation. Others are just tackling it through courses like the legal writing programs or lawyering programs. Others are packing it into clinical education or externship programs. And then law firms are all doing sort of different things too. And even the other day, I was just trying to come up with what is the most current set of lawyer competencies and skills we want our graduating law students to have. And there's such a variety of those too. So I feel like our profession could do a better job of kind of coming together and communicating. We talk about the disconnect between actual practice and the educators of law in law schools, and we're not talking to each other enough. And I feel like right now for students who really want to embrace lawyer formation, there's almost too much information and not a sort of a community-wide or well-communicated set of goals and learning competencies, learning outcomes that we want everyone to leave law school with and enter their first job, whether that's in a small firm, a big firm, in-house counsel, et cetera.
Yeah, especially at that connector point between law school admissions, law school, and then entry into the profession. As you both said, some law firms really have sophisticated development programs. And once you're there and you're well supported over time, it feels fluid, but feels very bumpy in those early years. And like both of you, I've followed all of these frameworks that have been developed by really exceptional thinkers in the space. But ownership and connection is really, it sounds like, what we need. Alice.
Yeah, I totally agree with that everything right now is kind of random and not well thought out. But I have to say that also, I don't think it's clearly valued. Like so many of the professional development programs in law schools are extracurricular, quote unquote. And even though they may be required, you don't get credit for it, you don't get graded in it. And I don't know how many of the law firms actually, I think they teach all that, but I don't know how much that comes into their reviews to success at the law firm. I really think if you think about lawyers over history, the ones that really shine are the ones that do have those interpersonal skills. But it was almost like, well, you have it or you don't have it, and nobody can teach it. And I think that we now understand that's not true. But I don't know that the legal profession clearly says, oh, yeah, you should know this, and it really is valued, and it will help you succeed. So I would like to change that.
I agree. I feel like a lot of these programs, they're all great programs, but they are sort of viewed as an add-on or a supplement, but not really infused into curricula or infused into training programs. And this is why I love to kind of analogize law students and lawyers to athletes or performers, that this stuff is not just extra or something that we'd like to have on top of the intellectual pursuit, something that should infuse everything we do as we learn how to be a great lawyer. And it will really just make us better at performing. It's not just something nice to have, but it's going to make us better at the high level performance that we all aspire toward. and that what law firms and in-house counsel departments want to get out of every one of their employees, have them be healthy, high performers at every level.
Yeah. And just to highlight a few of the themes that you're surfacing here, it feels like an incentives issue as well. To both of your points, when something is co-curricular, there's a message that's sent about that it's optional or it's a nice to have, not a core competency. And Heidi, I know you have an esteemed history as a legal writing professor, and legal practice skills and legal writing also seems like another place where frequently it's not graded, which I understand because you wouldn't necessarily want students to be judged for employment purposes based on their grades in legal writing. But also it creates the incentive to not focus as much on those core skills as compared with the doctrinal courses where you're getting graded. And also, we're all three of us fans of interdisciplinary learning. I think if you go to business schools, and I'm sure that they have their own challenges in their programs, but they really spend a great deal of time with cohort-based collaborative problem-solving projects from the very start, and emphasizing the power of their networks, the power of interpersonal connection. So I know all three of us would love to see more of that in law schools. Alice, I'm going to come back to you because like many people who start their career as tax attorneys, as you did, you then moved into startup world. Every tax lawyer I know ends up in startup world ultimately. And you had really a front row seat for thinking about entrepreneurship and finding opportunities in changing landscapes to contribute value, to build businesses. And I know now you use that experience to teach your own students entrepreneurial mindset, which sounds amazing, but I'm not really sure what it actually means to have an entrepreneurial mindset and how one teaches entrepreneurial mindset. So how do you do it and how do you think about it?
Well, first of all, I think that it is an entirely different way of thinking than the critical thinking of a lawyer. It's not adverse to it, but it's a different way of approaching things. And one of the things that I try to teach my students is you have to start with a beginner's mind, that you don't know everything and you're not supposed to know everything, but you want to take a really fresh look at whatever problem you're trying to solve to create a product or a solution for. And you can't do that if you have preconceived ideas or have looked backwards and said, oh, well, they used to do it this way. You have to really open your mind up. And then you have to be nimble. You have to be agile in that things don't work out. Your first thought might turn out to be really not what people are looking for, not really solving the problem. And as you said, you have to be collaborative because you need the stakeholders in order to build a product that people want to use. You have to talk to the people who want to use it. You have to talk to the people who are going to implement it and really understand what the problem is. Often we think we know what a problem is when you're looking at it, especially from like the top down. And then you talk to the people who are trying to do it and you're like, realized, oh no, it's got nothing to do with this. It's really about, they don't hear it well. And so you have to really be willing to dig deep in that sense and collaborating. And then you have to be able to fail, because of all the startup people you talk to, 99% of them have failed at least once. In fact, that's valued sometimes, like by Y Combinator. They want the team that has failed, right? And so I think that's a very different way of thinking. And for law school students, they've never seen that before. And so what I've done is I create problems or situations in which they have to do all of those things, because the goal at the end of the semester is they have to present either their startups, and these are legal, they have to come up with a legal tech startup idea and move it through all the stages that you would learn at business school, product market fit and business model canvas and all of these subject matter things that they don't know anything about before, and then be able to stand up and present for 10 minutes to investors or legal tech experts at the end of the course. And so it forces them to go through all the steps. So for me, that has been more successful than just telling them about it. I guess that's my own experience. I was a lawyer and I was trying to do a startup. It was in an accelerator and it really made me, I thought I understood business. And then I went into the tech world and I was like, oh my gosh, I know nothing about this. This has got different business concepts. They don't care that I'm a lawyer. In fact, they laugh when I say I've been a lawyer. They're like, oh, good for you. You've got a hard road ahead of you. And so it was in a way humiliating. And it was something I had to really work hard to get through in order to solve a problem, to embrace something new, and to ultimately learned so much more than I would have ever learned if I hadn't opened my mind up to a whole new discipline.
I think the concept of teaching the concept of failing fast, making mistakes is so exciting for me to incorporate that into legal education. I think you're absolutely right that students come to law school thinking, oh, I can't make a single mistake. I can't show fear. I can't fail. Everything is so high stakes. Life is on the line. The big job is on the line. But when I was researching, I wrote a book called Untangling Fear in Lawyering. And to research that book, I looked at exactly what you're talking about, what other professions are doing, like business school, entrepreneurship programs, engineering schools, and the medical profession. I mean, medical schools some of them have rooms they call mistake rooms, where the students actually have to go into the room and look for all the mistakes and make mistakes so they can anticipate and game out how to not make that mistake again. But the way we teach about mistakes in law school is about catastrophic ethical mistakes. And our students, I think, are left with this impression, well, of course, I would never do that. I would never make that mistake. But then there's no space in law school for them to make the little mistakes that get them comfortable admitting what they don't know. And there's such this mentality in law school of pretending and fake it till you make it. I mean, I can't tell you how many times in my life I've been told, as someone who grappled with extreme public speaking anxiety and, this intense fear of making a mistake, the mantra was fake it till you make it. And I just think that's the opposite of what we should be teaching future lawyers. We should create space in legal education so they can make mistakes in a safe environment. So then when they do get out there and the stakes are legitimately high, they know how to ask for help if they need it and make the right ethical decisions when things are on the line. And in my opinion, we just don't create enough space for that in legal education.
Yeah. And as you're talking, Heidi, I'm thinking about all of the great research Amy Edmondson's done around psychological safety and how important it is for surfacing mistakes so that you can get better. And I think, like you said, there's this element of shame and a myth that nobody else around you is experiencing failure or mistakes, and you need to keep it to yourself. My experience being a lawyer for a really long time is that until I had the opportunity to go visit with other disciplines, to work with people who were from design school, business school, engineering school, I didn't realize how different culturally it was. Like Alice is saying, I felt much more comfortable sharing sort of silly ideas or putting something out there to discuss. And that's because they're trained very specifically to encourage that. And in legal environments, by contrast, I'm always thinking, what are the risks of saying this out loud? What are the problems with this idea before having the benefit of other minds helping you tackle it? I want to ask one more question. And Heidi, I'm going to start with you just to play devil's advocate a little bit, because I've had this conversation with people about the concept Alice surfaced about nimble mindsets and adapting to change and flexibility. And I've had some law professors say that is what Socratic method teaches. And we challenge you to think differently. And in the moment, you need to be nimble and respond. And that is the skill that will prepare our students for the future. How would you respond to that, Heidi?
Well, as you know, I'm not a huge fan of the method of cold calling to the Socratic method. My position on Socratic method is first, like the things we've been talking about, we need to model what a Socratic dialogue is supposed to do. I joke with my students that I was mad at Socrates for a good 20 years for inventing the Socratic method the way I let it intimidate me in law school. But when you really study Socrates, it was about learning from each other and not pretending like we're the smartest people in the room, but really learning the art of asking questions to solve problems and to learn about ourselves and each other. So I would like to see the Socratic method change in law school in terms of, first, it's kind of like the see one, do one, teach one model, again, from medical education. First, students have to see and be taught how a Socratic dialogue is supposed to go. I don't like the approach that, we're going to throw you into the fire on day one in law school because we want you to be nimble from day one. Some students have never had that experience in their life educationally. And in my experience, we make it seem like students have to either have that skill or not have it, or they're not going to make it. But we can teach it. We can teach students how to respond to Socratic questions, how to prepare for Socratic questions, even when they're nervous or anxious but they've done the work. I mean, my greatest goal in life would be to help students stay in a Socratic dialogue when they've done the preparation, they've done the work, but they're just it's not clicking for them in that moment. Let's teach them that skill of how to stay in a dialogue, even when it's not going perfectly. So I do think there's merit to the Socratic method. I think the original ethos behind the Socratic method has great intentions, but the way I've seen it sort of misused in legal education, we're not teaching students how to be nimble. We're putting them on the spot to see if they can fail or succeed without teaching them the skill of how to do it successfully and stay in it when your body and your brain and your emotions are kind of freaking out. I'm a huge fan of teaching our students what's called somatic intelligence too, pairing their intellectual intelligence and their emotional intelligence with their bodily intelligence. That was always the hardest thing for me, understanding what was happening in my physical body when the fear, the fight, flight, or freeze would kick in a Socratic dialogue. Those are the kinds of skills we can teach our students. What is happening to them in a Socratic dialogue when they've got the answer in their brain, but their emotions and their physical manifestations of the performance anxiety are getting in their way.
I think that's really interesting you say that, Heidi, because I think the Socratic method, which has been in legal education for so long and taught of, spoken of as like an amazing process, is really rooted and maybe was reinforced because of all law school is pushing everyone towards litigation. And so maybe in litigation, you're going to be standing up in front of a judge and the judge is going to grill you. I don't know. I don't know if it's as much as it is in legal education that they grill you like that. And so there's something to be said for being able to think on your feet. But when you terrorize people from day one, to me, it creates a situation, an almost PTSD situation where they get in that situation and suddenly they freeze because of all the bad experiences they've had in the past. And so I would disagree with calling it something that teaches being nimble. To me, it means teaching, if you're right, you're all right. You're okay. But if you're not right, you've made a mistake or you just didn't say it the way that the professor wanted you to say it, you're dead wrong and you're embarrassed and you're humiliated. And I don't see that as nimbleness. It's sort of like throwing a surprise at somebody and then expecting that they have learned from that when you threw something at them that they didn't understand. I don't think that's nimble. Nimble is being able to rethink the way you were thinking about something. And I think that would be a great thing for us to do in the beginning, maybe the whole first semester, and instead of having it like a mental boot camp, to instead make it sort of a nurturing environment that helped people understand that they were going to have to learn how to think on their feet. But these are the ways to deal with that. And here, we're going to give you some easy, we'll throw you a softball at first, sort of bring people along. And I think that is something that we could adopt in legal education and do everyone a favor.
Yeah, I love this conversation. And first, just personally, that was my experience, Alice. And I know, Heidi, you and I have talked about this many times, is like when I went through it for a couple of days as a 1L, my response was just the rest of my time here, I am trying to avoid being in that situation ever again, versus I really want to engage and grapple with these issues. And the other thing that I'm going to just share with you, this is a story from my design thinking class that I love. We do, to teach students to sort of stop self-editing and get comfortable with failure, we do a worst possible idea exercise so that their challenge really is to be silly or to say something that wouldn't work. And we were redesigning the first week of law school. And one of my student groups' worst possible idea was to put people in teams to respond to Socratic method in the first week. And I thought that was a brilliant idea. I thought it replicated legal practice so much more. And it allowed you to actually, to your point, Heidi, some of these somatic responses to cure that a little bit, because the somatic responses of collaborating are the complete opposite. And the last thing I'll say, I know, Heidi, I want to come to you, is Alice, I'm going to echo what you said about litigation focus, and not just litigation, but appellate argument in litigation. And our colleague, Jim Sandman, who's on another episode, has frequently said this, that legal education is so designed around appellate argument before the highest courts of the land. He talks about it in an access to justice context. But I think it also applies here. That is virtually never the experience of even a litigator. It's not being put on your feet, to think on your feet in front of a judge and jury always. It's usually much more office-based and team-based than that. So Heidi, I'm going to come to you. I know you're chomping at the bit to bump in here.
Yeah, I mean, I could talk about the Socratic method and how I would change it all the live long day. But one other layer I'll add to this is that in legal education, we also should be understanding that students introverts and extroverts approach conversation and dialogue, highly intellectual conversation and dialogue differently. Like extroverts can very easily jump into and start speaking about topics because they formulate their ideas externally out loud. But introverts do that internally. So introverts are more likely to vet and test their words, their ideas, their responses internally before they begin speaking. But when you're in a high pressure or a societal expectation environment like the courtroom or like the classroom where an awkward pause makes everyone uncomfortable, introverts are forced to act like extroverts. But they really, when you give an introvert time, they can come up with something that they've really been pondering and thinking about for a while that maybe can explain a legal concept in a way that someone else in the room can understand. So I would love us to create more space. The pandemic actually helped introverted law students because studying and taking classes over Zoom, even just having the chat feature, enabled students to be able to write out responses to difficult Socratic questions, but they just had that extra 30 seconds. And I saw such an uptick in engagement from my quiet students. It was remarkable. And so I think if we create more space in legal education for our quieter students to learn how to speak about the law in safer spaces where they're not in the hot seat immediately, they really do learn how to amplify their advocacy voices externally and more extemporaneously just from having that practice. So I think, again, it's like kind of the see one, do one, teach one model. It's slow this whole thing down instead of expecting every law student to be great at the Socratic method on day one. It's not possible. And also it's just reinforcing the students who already have gotten the most attention their whole lives because they're good at speaking. There's other ways to be a great advocate.
True.
So it sounds like the three of us are in violent agreement on the current and historical state of legal education. And Alice, you mentioned Y Combinator, which was formerly led by Sam Altman, who has thrust all of humanity into an accelerated learning posture through his collaborators' release of ChatGPT about a year and a half ago, 3.5, and then about a year ago, unbelievably, just 12 months ago, the release of GPT-4. And so I think the three of us are, maybe a little anxious about the future, but also really excited because this feels like a real driver of change that we haven't seen before. And Heidi, I want to come to you because I know you're teaching new classes on legal writing and specifically focused on how generative AI will impact legal writing. I'm so curious about your thoughts about its potential impact and also where you think the opportunities and challenges lie in this new landscape.
Sure. Well, I'll start by saying, I'm a writer at heart. In my deepest soul, I am a writer. It's funny. I tell my students when I fill out forms about my occupation, I never use my fancy titles of law professor, or associate dean, or lawyer, or litigator. I always write writer. So when ChatGPT first barged into my legal writing classroom in the spring of 2023, I guess, without invitation, I had a little bit of a panic attack. But because I am a forward-thinking person, I actually used to be a world-class pessimist, but teaching brought out my optimism. And so I've decided to go all in with generative AI, and I'm excited about it. But as a writer myself and as a teacher of writing, I am resisting, and I'm giving my students permission to resist the pressure to accelerate everything at the speed of sound or the speed of light. All the media hype around generative AI always uses vocabulary around speed. Accelerate. Do you think, I saw something the other day, write a novel in 30 seconds. As a person who loves writing, memoir, genre of memoir, and really loves the process of writing, even though it can be grueling, I'm feeling extreme resistance to 30 seconds, in mere minutes. Yeah, because as we know, speed doesn't necessarily equate to quality. And there are tremendous opportunities here with generative AI and the art and science of legal writing. As I mentioned, I've gone all in educating myself on these tools and giving my students, I'm teaching 2 different classes around it, giving my students permission to use it for every assignment. I think when ChatGPT first came on the scene, there were a lot of reaction to it in legal education. Oh, we have to ban this thing. We can't allow our students to use it. But I came across a great article by Professor Scott Graham. I think he's at University of Texas at Austin. And he said, this is such a great moment to be a writing professor. It's a huge moment. And we got to step into it because there's new skills we can teach. Prompt engineering, obviously, although that will probably eventually go away as well. Output discernment, figuring out what good output from bad output. We all have heard about the hallucination issue that these tools can make up law, not maliciously, but just it doesn't know it's doing it. So teaching students the importance of site checking and resource checking. And then the new skill of taking a generative AI generated first draft and moving that along a continuum to a high quality, human vetted product. So in terms of opportunities, I definitely feel like generative AI, and I've already seen this happening, can automate more formulaic legal writing. Things like, let's take a big set of facts and the elements of different causes of action, legal causes of action, and quickly generate a draft complaint. Or, take a vast interview transcript or deposition transcript and quickly generate an affidavit that we can then edit. On longer form pieces of writing that require a lot more analytical skills, I have seen its difficulties in generating like high quality analysis in legal memoranda and briefs. I think it'll get there. But for now, I think it'll automate more formulaic parts of our writing. I also think it's awesome at being a brainstorming partner. I've had my students use it to generate themes for persuasive legal writing. I love the AI tool or the AI prompt called Tree of Thought, where you can get it to generate a debate among several perspectives. And that's what a great tool for lawyers to be able to game out arguments and counter arguments. Even things like make this heading of my brief more engaging. I'm still wrestling with how exactly to prompt AI to help it give myself, but also my students and junior lawyers, have it generate feedback on pieces of writing. I know Professor Ethan Malik and Lilach Malik have designed templates for using AI for feedback. Professor Joe Regalia at UNLV has written a draft article on how to use AI for feedback. And also Professor Joel Glad has some great stuff about how to create our own rubrics to teach AI to give us feedback on our writing. So I think those are some great opportunities there. I'm happy to talk about kind of challenges too, but I don't want to keep occupying the stage too long.
Well, let me ask you about a challenge first, and then I want to move over to Alice, because Alice is also teaching classes involving generative AI, and I want to hear about her sort of perspective on this too. But one challenge that I've been thinking about a lot, I'm also an optimist. I'm like all in on generative AI. I find it also to be an amazing creativity partner. But one thing I think a lot about is that the three of us came up at a different time as practicing lawyers. We did a lot of work in our early years that was really boring. And I know I hated it and didn't think that was why I went to law school. But it did teach me the building blocks very slowly of what a representation looked like and what the ultimate goal was. So there was something happening in my mind to form that future lawyer. And if those tasks become disrupted, replaced, mitigated, lessened by this technology, how will lawyers of the future learn, especially in firms, right, where the client frequently subsidizes that period of learning, and they will, I suspect, not be willing to do that for the midterm future. What do you think, Heidi? How will they learn?
Those concern me as well. And that's why I think that teaching in law school is going to still be so important, because if an AI tool can generate a brief eventually very quickly, a mid-level associate who hasn't gone through that learning process isn't going to know if that writing is good or not, or if the analysis is deep enough or not. And what I see in my students, they really wrestle and grapple with rule frameworks. And every good piece of legal writing stems from the structure of the rule that you're analyzing. And this is separate from contract drafting right now. I'm just talking about like legal analysis in the litigation context. So our students and the junior attorneys really need tons and tons of practice in taking a legal rule and breaking it down to either a checklist of required elements or a set of factors to balance and weigh. And that's hard. That's a hard thing to do. And AI isn't good at that yet. It doesn't know the difference between elements and factors in plain English sounds like the same thing. But in law, it's not. So I still think legal writing courses and legal analysis courses, every course that's dealing with rules, it's going to be on us to really honestly teach students how to understand the building blocks of rules and apply a set of client facts to that rule structure in an organized basis before we're able to tell if an AI generated product, a piece of legal writing is correct or makes sense or logical to the ultimate reader, either the judge or maybe a mediator or a client. And so that is something that we don't get that overnight. Students aren't even great at that after their first year of law school. I still wrestle with it after 3 decades of this. So I don't think that piece of learning can ever, well, I mean, maybe not ever, maybe at some point, but is not going to immediately disappear. That type of learning is foundational to using these generative AI tools as a supplement to our work process.
Thank you so much. And Alice, I want to hear about how you're teaching generative AI, because I know you're also teaching it to your students, but in a slightly different way from the way Heidi's teaching it. What are you teaching?
Well, first of all, I am teaching 2Ls and 3Ls. And so I'm also, I'm not trying to teach them sort of basic skills that they have to have as a lawyer that are so important. I'm trying to shake them up a little bit and get them out of thinking the way that they've been doing it, at least for their first year. And I've taught law and technology since 2017, and it's been a long slog because the legal profession has been so resistant to it. But when generative AI came on the scene, I was so excited because it seemed to me this is so revolutionary. This is going to change everything, and everybody's going to jump on board with that. That was sort of an overly optimistic view of the way lawyers react to change. But, for the last 2 years, I changed the class that I was teaching, which was technology more or less in the practice of law, just, like automation and document flow and data visualization. And I got into blockchain a little bit, but it wasn't as all encompassing as generative AI has been. And so last year it was all about, oh my God, what is this? And the students and I spent every week just learning something else and going, oh my gosh, GPT-4, what's that going to be? But this year I myself have gotten a little bit more of a grasp on large language models. And so this semester I've been teaching, which is essentially a deep dive into the technology itself, because my belief is that this is such an overall change in the way that the issues of law, the practice of law and the issues, the substantive doctrinal issues that they're going to have to understand, that I believe it's important to understand the technology, not so you could code it, but so that you really understand what's going on behind the door, so to speak. So from the very first day, I've asked my students or actually given them sort of assignments that they had to use 1 or 2 or more LLMs to answer a specific question. And so I started out, like write a letter to a friend, and then, write an empathetic letter to someone who's lost a loved one, write a demand letter, and then create an access to justice, create a solution for one area of access to justice that you're interested in. At the same time that we were going deep into, okay, so what does it mean to have a large language model? And how do they even begin to teach a machine how to speak English, right? Or any other language? And so, what was really fortuitous for me, I was able to frame it by the lawsuit that New York Times brought against OpenAI and Microsoft. And in that case, in the complaint, the lawyers for the New York Times did take a deep dive. They were trying to prove that, that OpenAI had been using copyrighted material and memorizing it. And so they had to go through all sort of, well, where did that happen? And how did that happen? And how did that impact the output? And so I was, I think that gave the students, that was the first thing I had them read this, and then work with an LLM on your own on something else, but so that they could see that it wasn't going to be important. Like, yeah, it's just copyright law now, but it's going to be impacting pretty much everything, I think, within just a number of years. And I gave them, so the frame for learning all of this has been copyright law all the way, because it is so much farther along in terms of judicial decisions and articles and so forth. And so I asked them as a midterm I told them they were working at a law firm and they had a client that wanted to build her own LLM. And the partner was asking you, because he had a meeting the next day with the founder, to give him some understanding of how he did 3 cases. I just listed 3 cases that were important, had some technology aspect to them. Said, how did these impact? What do you want to tell the partner about this? And what's the advice he should give the founder? So interestingly, actually, for Heidi, and I said, this is a business email. I want you to write something. I want you to use the LLMs, get as far as you can with an LLM, and then write your own and make sure it's something you'd be proud to send to a partner. Well, first of all, I realized students have no idea how to write a business email. A lot of them just gave me a law school exam answer where you throw everything at the wall and say, see, I see there's an issue, but, as opposed to, well, okay, but this is what you have to do about it. But we all found it. I've realized this too, from doing this, using first the LLM to do it, is that they can give great summaries. They can give you a glossy, knowledgeable sounding essay, but they cannot, in a nuanced way, analyze a case and the holding of a case and apply it to these very unusual facts that you have to have the nuanced understanding of the technology to understand that even though, the Napster case had, completely different kind of technology, the things that the judge said, you have to think about that impacts how you build your LLM. And some of the students never got there because they weren't willing to really do that deep dive, and they let the LLM summarize the cases for them. And so the takeaway that I tried to give them after this was, you cannot, even though they may summarize it correctly. Interesting, a lot of them were dead wrong about the holding, but you can't. You have to read them, whether you read them first or second, it doesn't really matter. But you have to read them and you have to think it through. And the LLMs can give you some ideas and maybe you could ask them to think about something in a different way, but it's not. You can never completely rely on it at this point in time. Now, maybe that will change down the road. But what I think the students have some of them came into the class never having tried any large language model because, the school, certainly the first year was like, oh my gosh, don't. And most professors are still don't. And what they've learned is that they're fun uses of it. They use it in their daily lives. They use it occasionally. I found a prompt actually from Ethan Malik from Penn that you can put into your, into Claude or ChatGPT or whatever, that asks the large language model to be a tutor and to give feedback in a certain way. And I had them all do that in class for various things and also for this midterm essay. And it's fascinating how helpful that is. You're asking for feedback and you're getting it right in real time. And you can say, well, what do you mean? Why should I have looked in more detail to that? And you get an instant response. And it's very helpful. I think that's how it could be used as a tutor from the very beginning, as a coach, and then like you said, Heidi, like somebody who can argue with you. Actually, one of my students in my Building a Legal Tech Startup class, they wanted to create, using generative AI, sort of an avatar that would take the other side that you could see on the screen and would respond in real time to you. Now, that's not yet there, but how great would that be to be able to practice whenever you wanted to, and then you could tell them, well, be aggressive. No, be a little bit more, pleasant in how you deal with this, or really nail me on these things. I don't know. I think there's a lot of possibility for how we can use them. And I do think, to your point, Heidi, that, well, and Jen, you said the same thing, that it's sort of, we learned while doing, and that was okay. And yes, clients paid for it, but it's also that those are skills maybe that can be learned that way. And we're successful. We did all, maybe a year or two later, I learned how to be a tax lawyer, and understand those complicated deals, But now what we want to do is to teach the students to be able to, when they go out into practice, to have the understanding that we got from the 2 years of reading documents or writing briefs or, doing due diligence or whatever. We should do that in law school. So we should teach them how to write so that they can edit the first draft that comes out, or we could teach them what the elements of a contract are. And so they can see, they know there should be an indemnity clause. They know that there should be, some sort of force majeure clause, all of those things that we do have contract drafting classes for the higher end, but I've had students tell me they'd never even heard of an indemnity clause until they got out of the world. So I think we need to rethink how we do that, because then we have a chance of creating young lawyers who are really valuable and whose time does not have to be written off. So I think it's an exciting opportunity for generative AI. That generative AI has come. I just hope more people join us.
I'm excited too. And I love that you mentioned the word fun. I actually want to respond to 3 things that you said, because now you've got my brain like bursting with ideas. But the first thing I wanted to respond to is the fun. And I think for our students and for our colleagues and for maybe people in the profession who are resistant or nervous or scared to even try the technology, it's the fun aspect of it that I think can be sort of a gateway into using it for the more sophisticated side. I mean, I agree with you. Like, I had my students use it for fun things. Write a haiku, have it write a haiku about something that you love doing. Also, I think that image generators, ChatGPT-4, DALL-E, how fun is it to ask it to create an image that you have in your head? But like, I don't have an artistic bone in my body, but I have a wildly creative brain. So I have the idea of what I want an image for my PowerPoint to look like, but I don't know how to create it myself. And I don't want to use a stock image. That the image generators that AI have presented to us are just hugely fun to use. And I think for students who are wrestling with legal concepts they don't understand, if they can create an image that encapsulates a legal concept that they can remember then on the exam or in the bar exam, or just have it makes more sense to them, that's a fun sort of gateway or on-ramp to using this technology for more high-level purposes. Second, you mentioned how our students don't know how to write business emails. I had my students I used the AI tools in class to get them familiar with using them. And then in a whole meta assignment, I had them write a memo around the state of AI in the legal profession. And so they had to explore our ethical obligations to become up to speed on technology. So the ABA and the New York rules about technology competence. Second, they had to take 2 sets of judges' standing rules. So far, I think I think this is correct, that only 2 judges based in New York have standing rules related to generative AI, but judges all over the country have issued standing rules. But they're concerned about different things. Some are concerned about hallucinations. Others are concerned about client billing practices. Others are concerned about the confidentiality risks. So the students had to research technology competence rules, judges' standing rules, 3 jurisdictions' ethics opinions, and then I think now we're up to 8 cases in which lawyers have been reprimanded for citing hallucinated cases in briefs without checking. So I thought it was a pretty easy assignment because I wasn't giving the students a fact pattern. They just had to write a memo on the state of the law right now. But the last section of the memo, they had to basically act like they were educating their law firm on and coming up with ideas for how the firm could embrace this technology, but look forward and educate the firm on things they could do creatively to get up to speed on this technology. And I just graded all those memos, and there were some good ideas in there, but I really wanted my students to go further and adopt that entrepreneurial mindset. And I don't think I taught that aspect of the assignment well enough to prepare them to do that. But that's where I think creating space in law school for students to be creative thinkers, problem solvers, have come up with the worst possible idea that could actually be the best, to Jen's point earlier. And then one last point on, I too grew up in the legal profession when we reviewed every piece of paper in the evidentiary record by hand and did privilege review. And literally, I remembered even when we were reviewing emails for privilege, I literally sat at a laptop and clicked forward for hours. I practiced construction law, and we had 5 million pieces of paper we had to review in privilege review. But you know what that task enabled me to do? I was the most knowledgeable person on the litigation team about the facts of the case because I had read every document. And well, now I do think, that process is wildly inefficient. And obviously there's AI tools and other document review tools that lawyers should be using because it's a waste of hundreds of hours, thousands of hours for an associate to be doing that. But we need another way for the associates to be that person with all that factual knowledge. Because when I sat down to write the brief about the case, I knew what facts needed to be in that brief. Whereas if I'm just reading a much smaller file generated by AI, I don't know that I'm going to feel that level of confidence that I felt as a writer back then. I'm sure we can get there. There are other ways of doing that, but I just wanted to flag that as an issue that, yes, those tedious, awful tasks we used to have to do, they did serve a purpose. And I'm hopeful that we can find another way for our junior lawyers to gain those skills and the confidence. For me, it was more about the confidence building, that while I wasn't confident in my public speaking, I was really confident that I had done that grunt work to be knowledgeable deeply about the nuances of the case such that I could amplify my advocacy voice through my writing. So that's just something I hope that we can figure out a way to inspire our law students and our associates, that sometimes that work that seems so useless actually does serve some purpose.
Yeah, absolutely. And that's what I've been thinking about the most, is that deep learning that happens through that deliberative, constant review of the information. But I also want to avoid being the person who did doc review, 3 miles in the snow uphill, and there's no possible way that anybody could ever learn this that way. So I'm excited to see how the lawyer formation in the early years in the future changes. 2 things I just want to add to this conversation, because I could talk about this all day, and we'll have to have you back after GPT-5 comes out and see where we are next year. But one thing I've really been noticing in traveling around the profession and talking to practicing lawyers is a surprising lack of skepticism about the impact of this technology. I always expect to have to make the case more fervently than I do. And I think in many cases, in the private sector, at least, that's because firms are already hearing from their clients about strategy for incorporating this specific tool. So I think that's sort of exciting. We're definitely more skeptical than other industries, but we're moving faster than I expected us to. And the other thing I'll just add is I share your enthusiasm around this technology as a tool for feedback and formative, real time, as frequently as you want it in a comfortable environment. I hated in law school getting that sample exam in the library that was so well written. I couldn't even imagine putting that together, but I also didn't really understand what was so great about it. Like, I knew it was really good, but how it was really good, I didn't know. And it just freaked me out. And I've heard, some law school faculty sort of grumble about this idea of generative AI giving feedback, that, like, I don't know what it's going to say to them. I would prefer to be the one giving it feedback. And I'm going to echo another one of our guests, Andy Perlman, in the access to justice context of generative AI, which is compared to what? Relative to what that they're getting now, which is virtually nothing. And I think in the law firm context as well, instead of having to walk into a scary partner's office and take up their billable time by asking for feedback, being able to use retrieval augmented generation to get direct feedback from their prior work product. So we're almost out of time here. And I do want to end there on this topic, which is we've talked a lot about what happens at the law school level. And we're starting to think about what happens on the law firm side once our graduates go to their employers in the private sector. And the 3 of us have spent time separately sort of dreaming about the law firm professional development program of the future. And I think the moment really is here to be designing something totally new. Alice, I'm just going to ask you briefly to share with us as we close out our interview today, what you would do if you could design a law firm professional development program for junior lawyers from scratch. What major topics and themes you would cover through that programming?
Well, it's most of the things that we talked about today, really, that they're all the leadership skills, the entrepreneurial kind of mindset, or a different mindset than lawyers typically have graduating from law school. And then also all about this generative artificial intelligence, because their careers are going to be shaped by it substantively and also practice-wise. And the other thing I think that I've been teaching my students lately is business of law. They don't understand. They've heard about law firms their whole lives, but they don't know the incentives, the way they work, what they're sort of walking into. And I've tried to get them to understand how it works and what, as an associate, what the forces are on you as well as on the partners. And really the business model of law firms, the billable hour, is one of the reasons that I think lawyers are resisting generative artificial intelligence on, implementing it on their own, because it is about less billable hours. And how do you do that when that's where all your profits come from? And I do think, and that's again where the pressure from clients is going to force that, where clients say, I'm not paying for all those hours because we did it in 2 hours on our own. And here, take this, take our polished draft and you just, add some nuance to it. So I think that all of those things are that recent grads are going to have to grapple with over the span of their careers. And so I'd like to give them the tools for that. And I think that's something that they could have as they start working in the law firms. It could be part of their first year as an associate, so that when they end that year, they have not only the work experience that they've seen now and really maybe understanding the business email in a way that they didn't before, but also some of these other things that could be taught that they could then just, jump out and be a really valuable lawyer. I would like law schools to do that, but I don't think they're going to do that for a while. Legal education hasn't changed for 130 years, and I don't think it's going to take a few more years before it's different. And I think in the meantime, there are a lot of things that could really help young lawyers and, frankly, partners. I mean, explaining generative AI to any lawyer is a really valuable thing because they're going to start seeing it in the issues that they work on.
Thank you so much, Alice. So Heidi, to close us out today, I'm going to just list some of those skills that Alice enumerated and see if you have others to add. Entrepreneurial mindset, leadership and interpersonal skills, understanding generative technologies, and understanding the business of law and incentives, particularly as the billable hour model shifts and changes. What else would you add to that list?
Two other things I would add to professional development in law firms, getting in how to get and give feedback. I think that's something that we don't teach well in law school. And also, I'm not sure it's being taught how to get and give feedback, because our lawyers are going to move up in the ranks and be givers of feedback eventually too. And then again, I want to just echo or reiterate the athlete performer model that I mentioned earlier. In the athlete world and performance world, there's a lot of focus on, there's actually this Russian sports psychologist coined this term called the individual zone of optimal functioning. And he did a study where in the 60s and 70s of athletes and figured out that every athlete has an individualized zone, not a one-size-fits-all zone, but an individualized zone of optimal functioning where they perform at their optimal level. And a lot goes into that. It's physicality, it's our positive and negative emotions. So a lot of these like soft terms, I think in professional development programming, we can help lawyers regard themselves like athletes and performers and be able to discern what is your individual zone of optimal functioning? What are the environmental circumstances around you in which you perform at your peak? What time of day do you get your peak performance? Not to dumb down or reduce the rigor of our profession, but actually up our game if we are aware of these things that toggle us into our peak performance. And the other thing is the concept of flow. Mihaly Csikszentmihalyi wrote that great book called Flow. And I don't think we talk about that enough in lawyering, that all of us as individuals have different flow states. I mentioned earlier, I love writing. Writing is my flow state. So if we help lawyers become aware of the tasks they're doing throughout their day in which they can hit that state of flow and everything's kind of clicking and they're really enjoying that work, then we can discern the tasks that we're doing as lawyers in which we don't hit a state of flow and see if those tasks are the ones that generative AI can help us do. Because for me, I don't want, I mentioned, I love the process of writing. Those are my fondest memories as a lawyer, of sitting down with my cases and my statutes and my facts and doing the grunt work of writing myself. I wouldn't want to eliminate that from my life as a lawyer, but there's ways that I could do that more efficiently through generative AI. So I think to wrap up, increasing our self-awareness, what is our individual zone of optimal functioning? What are our states of flow and how those are different? I would love for law firm managers to realize that those are different for each of our athlete performer associates. And that's okay. We don't need a one-size-fits-all mode of teaching legal education, and we don't need a one-size-fits-all mode of training really high-performing lawyers. We can get maximum performance capacity out of everyone if we regard them as individuals and really listen to how they can perform at their peak and enjoy doing it at the same time.
Oh my gosh. I love talking with both of you so much. I think in the span of 10 minutes, you've outlined the curriculum of the future for law firm professional development, entrepreneurial mindset, leadership, generative technologies, business of law, giving and getting feedback, athlete performer model, mindset, metacognition, lifelong learning, self-awareness. We need to go build this. So Heidi Brown, Alice Armitage, you are doing so much to support the humans of law during this interesting time. You are two of my favorite humans of law. I want to thank you for spending your time with us today. And to all of the humans of law out there listening to us, thank you for spending time with us today. We look forward to seeing you in the future for another episode of Fast Tracked Emergent Issues in the Legal Profession, produced by the Practicing Law Institute. Thank you, everybody.
Thank you for joining us on Fast Tracked. I hope you enjoyed this fascinating conversation as much as I did. Visit pli.edu for more insights, education, and resources for navigating this dynamic landscape. And until next time, stay curious and stay adaptable as we work together to chart a course into an exciting future.